Marty from Dog's Blog for the noontime report of the morning session of the Frank Carson et al. Trial on December 18, 2018. Court scheduled start at 9 a.m. this morning. Jury was not scheduled this morning. They're scheduled for 1:30 this afternoon. They were doing motions this morning. And Judge Janiga, of course, was late. First day of the week. This is her Monday. And it's no jury coming in, so of course she was called in that she was going to be late and got here around 9:20 or so. Got on the bench right away. She was talking about the motion to dismiss. She read Marlissa Ferrer's opposition to the time limits in regards to the case that's being put on. Defense has filed a motion to have time limits put on in this case to get some time of finish time, as we've been going on for a long time now. She said she's read Marlissa's Ferrer's opposition. And Marlissa Ferrer noted that she was not aware if Jai Gohel filed his own motions, which he had. She just couldn't find it initially and then did. And judges, knowing defense is filing an undue consumption of time with these all the witnesses and the issues going on in this case. So she's took it on their briefs, didn't take any oral arguments. That's going to be determined at another date. Apparently there are some more issues involved, and she's going to discuss that. It'll probably be next month after we come back from the break. She started talking about Jack Abel and his work product exception that he's claiming in regards to his investigation done. He was hired by Frank Carson and looked into the disappearance and the issues going on with law enforcement. Percy Martinez argued the judge needs to take this information from Jack Abel in camera, in chambers, by herself, and determine if there's anything that's work product or that can be turned over or not. That's the best way to decide this, and he says there is case law that says that can happen. Judge Aniga said she does not disagree with Percy Martinez, and she was reading some text from case law in regard to work product, but she says none of it really goes to point of a private investigator that's hired by an attorney. But she said not all information by a private investigator is work product. It all depends on what it is and how it's obtained. Judge Aniga says she does need to look at the information and decide if it is involving witness already testified, if there's witnesses that haven't testified, and in regards to the defendants, or any witness that have not been called by the defendants defense as of yet. She says that all plays into it. It's very complicated. She says she's also concerned about Robert Woody and his multiple statements involved in this entire case, and she gave him credibility at the prelim, but now she's concerned about him. I don't understand that, but so she's going into chambers and she's going to read the documents. Percy Martinez also requested that the phone records of Corey Kaufman phone be turned over, as they don't have the actual phone records. They have an interpretation, what he called an interpretation of phone records. And he said, according to the testimony of Deputy Cherie Hendricks out of Mariposa County, in her 2013 report, Corey Brown arrived at the scene, and he said he made statements that Corey Kaufman had been in Mariposa and there were CDRs in the Mariposa area at the time that he went missing. Corey Brown made that statement, and he says that there's information should be more accurate then, as they don't have the CDRs of Corey Kaufman's phone. And pinging telephones is the most common way to track down people these days. It's one of the first things that law enforcement does these days. Corey Brown said that he had, or told Cherie Hendricks that he had those records, Corey Kaufman's records. Marlissa Ferrer said the defense has the same records that she has turned over. She has the same records that has been turned over to the defense during the discovery process. That's all there is. That's all they have. This is what came from Cricket cell phone company at the time. Cricket had no GPS capability in 2012, and these are the only records available. She says they're more than welcome to subpoena Cricket and try to get those records themselves. Marlissa Ferreira said the defense has the same records that she has. There was an error in the report by Cherie Hendricks, and that it was actually that Frank Carson was in the area of what Corey Brown was saying. Again, Corey Kaufman had no GPS capability at that time. These are the only records available. Percy Martinez argued that what the defense has is not records, but some interpretation of data and no actual CDRs. CDRs are called data record of cell phones. Unknown what DA has alluded to or relented to properly to the defense. Marlissa Ferrer said what defense has is directly from Cricket and what they turned over everything that they have some time back. Judge Iniga suggested that the defense do an SDT as a subpoena duces token, basically get a subpoena for records from Cricket, but it won't do any good. But she also noted the pattern of Cherie Hendricks in this case. It does not surprise her that the report may not be accurate as some of the way things went Cherie Hendricks. Many things in the report were not accurate, and the investigation at the scene was not accurate as she collected the clothing, never photographed it, never marked it, never measured it, never did anything, and guesstimated when Stanislaus County came back up there to where things were. She also gave the defense several options and how they want to decide. They will make that determination. Judge also noted on January 11, 2019, there's a juror that needs a day off as her husband's having surgery, and so they're going to be off that day, so they're scheduling some motions for that date for January 11, 2019. Jai Goldhill started discussing the monies paid to the sheriff's office as per Corey Brown and the information they attempted to bring out. Some information has been received but not complete. There is a district attorney there's been some documentation turned over by the district attorney's office, but DA has advised that the county council is now going to have to be consulted to retrieve all of these properties. They then started talking about the motion to reconsider Leonard Hall conversation as a discovery violation by the DA's office. The defense says that Hall failed to notify Marlissa Ferreira had talked to Hall had talked to, let me go back. Heather Hall had called Leonard Hall and told him that they were trying to get a hold of him in this case. The DA feels that there's some type of instruction or something going on, intimidation or whatever by the family. They were trying to get a hold of Hall to come in and maybe intimidate Hall to not come in or whatever. She wasn't sure what was going on. There was a prosecutor did talk to somebody from the prosecutor's office did talk to Hall. I'm saying this very badly. I apologize. And actually, it was a staff member. It wasn't an investigator or an attorney. Marlissa Ferreira was not Brady information. It was not an interview, so it wasn't Brady information. But this was somebody from the prosecutor had talked to a witness in this case. And this is the arrangements they had made for Hall to come back here to testify. Jack Goldhill said that the DA has to disclose any statements made by a witness to be called. It doesn't matter who talked to him if he made a statement. He said it's under 1054 PCA, and that's under the, I believe that has to do with evidence and stuff. Any evidence has to be disclosed immediately. Once the information becomes available, they have 30 days prior to the beginning of the trial. Within 30 days of the beginning of the trial, they have to turn this information over, or when the trial is in process, they have an obligation to turn it over within 1 day, and that's by law. Judge Iniga started citing case law. She said that Marla Ferreira, not interview or a statement was taken by Leonard Hall. It was the support staff in the office that had talked to him. There was an objection during her cross-examination direct examination of Leonard Hall. They went to a sidebar, and the witness heard from his ex, Heather Hall, during a long claimed that he heard from his ex, Heather Hall, and that's when he had made contact with the DA's office. And there was a long discussion in the sidebar in regards to this. The gist of the Marlisa Ferreira argument, it was circumstantial evidence of Frank Carson using family to get to the witness. Marlisa Ferreira said the family had put Heather Hall up to it. Up to it meaning call Leonard Hall, didn't tell him that they were trying to get a hold of him. Judge Zuniga stated she's seeing no link of anyone contacting Leonard Hall. She advised Marlisa Ferreira there's a little too much speculation going on with this. Marlisa Ferreira wanted to show that Heather Hall was being manipulated by on Frank Carson's behalf. She says it just doesn't flow for her. The DA, the information should have been disclosed as per Brady immediately, as this was done during the trial. The defense motion is upheld. Again, the result of that being held will be heard on January 11, 2019. That date was just vacated the jury, and so now we're doing motions on that date. So now they're going back to the defense motion in regards to trying to get a date, limit the time of this case and try to get a finish date, as Marlisa Ferreira refuses to do it. And Judge Iniga says the court does have a right to control the process, as the defense has been arguing. She said, reading case law of court abilities and procedures, the issue is not in front of her. The issue in front of her is to set some time limits for the prosecution and her presentation of this case. There's not been any case law or authority to do so. She says she has no authority to put a time limit on anybody's case, as the judge is not allowed to do that. She says it may put a disadvantage on the defendants in the case, but that's just how it works sometimes. But she said also noted defendants are not in custody, so there's no prejudice. Agrees it is taking a long time, but is limited by law. But she does have some 352, which is the ability to make decisions in the case to limit cumulative exams. And she noted too that Marlisa Ferreira likes to redirect. She keeps going back and redirect it again, and that's exactly what she said. She noted there are objections constantly when she's doing this of cumulative by the defense, but there's no legal basis, she says, to put a stop to it. At this time, the judge went into chambers to review. It was around 10:30. The judge went into chambers to review Jack Abel's information of his claim of work product. And she said the court's can return at 11. Everybody can return at 11:30 to get what she has decided. We came back at 11:30, and she says there's 5 hours of interviews. There's a lot of rough notes to go through. She listened to an interview with Sean Grenold's, Kathy Grenold's statement, and part of the Atwell statement. She says the DA is trying to get the Atwell's statements. It looks to me that's what the biggest thing that DA wants, the Atwell statements that were to Jack Abel. Well, the purpose of work product and how the law protects it as being privileged, it does so attorneys cannot have an advantage to a witness statement that other attorneys cannot have than opposing attorneys may not have. It's done so attorneys cannot make a witness statement and keep from other parties having access. So she's saying it's in this case it would be Percy Martinez would have the advantage of having the access to those statements, and the DA wouldn't. So she said there is a defendant in this case, and the statements, turning the statements over to the DA cannot be done unless this defendant, she didn't say which Outlaw it was, but I believe it was Daljeet, he takes the stand, and then it may be used at that point. So there's no case law as procedure. She cannot let the prosecutor gain an advantage over the defense, and the defense take the stand. The defendants take the stand. It's not going to be allowed. So any statements that the defendants made to Jack Abel, mostly the Outlaws, well, it's not going to be turned over to the DA, at least at this point, unless, of course, they take the stand, and then it could become in play. Also on some of the tapes was she noted some of the names: Sean Grenold, Charlie Odell, somebody named Dickinson, somebody he was in custody, and he overheard something between Cooley and Odell apparently. There's Bill Borba, somebody by the name of Cosuelos. He says the statements are protected by work product, but some of them can be turned over. So there are some statements that are work product that are privileged that cannot be turned over. Basically the Atwell's calls. There's other ones that can be turned over, which are going to work out for the defense anyway. So that was the noon hour. We're coming back at 1:30. The jury's coming back, and we're supposed to hear from Praveen Singh this afternoon. There will be a podcast tonight.